The education law case of Zorach versus Clauson, 1952. The Zorach versus Clauson case was presented to the Supreme Court of the United States concerning a school district allowing students to leave school for part of the day to receive religious instruction. This case was based on the First Amendment of the United States Constitution, prohibiting the making of any law respecting an establishment of religion, impeding the free exercise of religion. The roots for release time education come out of a long heritage of Bible studying in public schools. It goes back to the early years of our country when Bibles were a classroom textbook. For example, in 1781, Congress approved the purchase of Bibles to be used in public schools. In 1803, President Thomas Jefferson required Washington, D.C. to use the Bible and Watts hymnal. The famous McGuffey reading published in 1836 taught Bible verses along with ABCs. Release time grew and flourished by 1942. Participation reached 1.5 million students in 46 states. Release time peaked in 1947 with 2 million students enrolled in 2,200 communities. During this time, favorable release time legislation was adopted by 12 states. In 1945, Vashti McCollum, an atheist, brought legal action against the Illinois Board of Education. At this time, over 40% of all release time classes were held in public school classrooms. McCollum argued that religious instruction held during regular school hours on public school property constituted an establishment of religion. The Supreme Court of Illinois voted against McCollum, and the United States Supreme Court reversed that decision in 1948, and was held to be unconstitutional because it used the state compulsory education system to aid in the teaching of religious doctrine, and because tax-supported school buildings were being used. In the aftermath of the Supreme Court decision in McCollum versus Board of Education, New York City began a program in which students in public schools could be dismissed from classroom activities for certain periods to participate in religious instruction elsewhere. Did the New York Release Time program violate the Establishment Clause of the First Amendment? In 1952, a New York Release Time program was challenged. The New York court upheld the program. The decision was appealed to the United States Supreme Court, which led a 6-3 decision. The court held that the release time program neither constituted the establishment of religion nor interfered with free exercise of religion. We are a religious people whose institution presuppose a supreme being. When the state encourages religious instruction or cooperates with religious authorities by adjusting the schedule of public events to sectarian needs, it then follows the best of our traditions, for it then respects the religious nature of our people and accommodates the public services to their spiritual needs. To hold that it may not would be to find the Constitution a requirement that the government shows a callous indifference to religious groups. That would be preferring those who believe in no religion over those who do. We find no constitutional requirement which makes it necessary for government to be hostile to religion and to throw its weight against efforts to widen the effective scope of religious influence. Justice William O. Douglas, Zorach versus Clauson, 1952. This has opened the door to many religious time release programs throughout the United States. On a national level, there is great information on time release programs through Release Time Bible Education at www.releasetime.org. Currently, it is estimated that there are over 1,000 release time programs in operation today, involving over 250,000 students in first grade through high school. Locally, we have time release programs from Launch Ministries, Inc., called Launchpad here in Southwest Idaho at www.launchministries.org. These are the citations I have in regards to my PowerPoint today. Thank you and have a wonderful evening.